That was S-45 was a Senate bill. Obviously, it passed the Senate, looking in a certain form, which we didn't see, although I think Mike made some references to it as he was walking through it. So, Steve, you may want to talk about the version that passed the Senate, which is fine. We don't have the bill hasn't been voted out in the House at all, and we don't have possession of it, just as a reminder. I'll just sort of summarize to set the stage here. I think that what we heard from Mike O'Grady last week was that we have an existing so-called right to farm law. Every state does. We've had one for several decades. Steve, you can more specific, I'm sure. So this bill the intention of the bill is to make some changes to that existing bill. I'm just going to editorialize a little bit and then ask that we don't editorialize. But I get a little hung up on the right to farm piece because there's a right to farm in Vermont that exists outside of this statute. This statute is not really about the right to farm. It's about, I would say, the right to legally engage in or create certain what are technically called nuisances, and be allowed to do that. And that you can't do that necessarily, can't do those things if you weren't farming. So being a farmer gives you that right. So let's go ahead. Steve, I know you've got lots of background for us. As I mentioned earlier, I'm hoping that we won't spend too much time editorializing, only because I want to make sure that we hear everything that Steve has to say. But we may get through your presentation and then have time to have conversation today. If not, we'll have plenty of other opportunity. So I'll turn it over to you.
Well, thank you so much. And good afternoon, everyone. Steve Collier from the Agency of Agriculture. And just on this point, we are very interested in this bill, and we'll talk to you as much as you want to hear from us. So if anyone's questions are not answered, we're happy to come back. We're happy to share cases, happy to do anything else we can. And the reason that we're really excited to be here talking about this bill, this is something that farmers have been trying to change for years, and we have been participating in trying to change that for years. And the reason is, and we'll talk about this in some more depth, but the current law is really poorly constructed. And so it's incredibly important, we think, for farmers to have the protection that most states allow for farms, and the state of Vermont currently does not. So we've been working on this for years. Your committee actually most of you were not on the committee at that time, but your committee was instrumental in the last significant change, and that was back in 2022, when none of the legal requirements changed, but this committee was trying to change them, and the bill never came out of the Senate. But your committee was able to better define the scope of activities that are covered by right to farm. So you actually amended the definitions back then to include both the definition of farming, that's in Act 250, which is the standard definition of farming. And you also clarified the agricultural activities, which was important because you basically made it clear that if you were engaged in farming activities, this protection applies. But there wasn't the sort of stomach at the time to address the actual substantive protection. And that's what this bill, what S-45 does. We're very pleased in the Senate, the House, the Senate Judiciary Committee voted for it 4-1. And the Senate actually approved the version that passed the Senate 25-5. And every member of the Senate Agricultural Committee supported it. So it really was, I think, very reassuring for a lot of farmers that we speak to, and also to us that farming is being prioritized in this bill. And the chair just talked on there's a lot of, I think, confusion naturally about what this actually means. As incredibly important as it is, it doesn't protect farms from being sued, not even for nuisance claims and not even for potentially trespass claims. But it would set a standard so farms know what they need to do to be legally safe. And it would also set a standard for other people in the community to know what farms can do and what they can't do. So I think I would say the version that passed the Senate, 25-5, the Agency of Agriculture is completely supportive of. We're very comfortable with it. We think it made a lot of great changes that we continue to support. We've testified and I've engaged with the House Judiciary Committee a lot since the House received the bill. The House has sort of been grappling with some important issues, and those are still in front of the House. And I still think overall the bill is in a good place, but there is it needs some refinement in our perspective to sort of address some of it. It's become less clear, more confusing, and less protective, which is obviously a policy choice that you all might want to make. But we still think, even with the version that's in front of the House Judiciary Committee, it would be a really important substantive change compared to the protection that Vermont farms have right now. So we're very pleased that we are where we are. We do prefer the Senate version, but there's some complicated issues about what the House Judiciary is talking about now that I'd love to engage with all of you on, so you have maybe a little bit better understanding about that. The reason this issue matters is what the heart of what this committee does is because of what farming is to the state of Vermont. And when the legislature adopted the current right to farm protection, which I believe was in 1981, there may have been something that existed that before that, but the current statutory protection that's there now, I think started in 1981. And the purpose section that the legislature enacted when it adopted the right to farm protection is perfect. It says why it's so important to protect farming. It includes the economy. It includes that agricultural land is an irreplaceable resource, which is true. Once ag land gets developed, it doesn't come back. Once it gets grown up, it's very unlikely to come back. So those are, the economy and agricultural land, very important. It's also the legislature recognized that it's important to have agriculture to preserve the landscape and our environmental resources, that it's also important to promote tourism, and that it's important for Vermonters' own self-sufficiency. Of course, what is farming all about? For the most part, food. If we can't feed ourselves, nothing else really matters. So, and another thing that the legislature recognized was that farming is important to the general health and welfare and benefit to the state. I mean, that's absolutely true. And that, in our opinion, is a concept that was once widely appreciated and has become somewhat lost. You think historically in the state of Vermont, we're a tiny state, second smallest state in the country. We love our state. We don't have a lot of industry here. Farming, agriculture have always been key to Vermont. Just taking a quick 100-year, and you know all this, but I still think it's important to frame why the protection matters just briefly. 100 years ago, about 80% of Vermont was covered in farmland. And that farmland has been disappearing rapidly for 100 years. So in the 1960s, when about half of the farmland had been lost, people got nervous. And Governor Hoff actually chaired a commission in 1968, which led to the adoption of Act 250. And the point of that commission was to recognize that Vermont was rapidly losing its farms and farmland and was losing that mostly to development. So Act 250 was largely enacted to try to protect those resources and to allow farming to thrive. So Act 250 was enacted in 1970. Since that happened, Vermont has lost an additional, since that time, 56% of its harvested cropland. So despite that protection, a little over 55 years ago, we've lost 56% more of our harvested cropland. At that time, there were about 4,000 dairy farms in Vermont. There's now 439. So when you talk, and anybody who grew up in Vermont, who's lived in Vermont, you don't have to drive very far or take a hike very far in the state or go anywhere in Vermont and recognize how much farmland that used to be populated with cows and dairy farms is now something else. So this is an existential sort of question about what is the state of Vermont going to be. When you're down to 10% roughly of the farms that you had then, that's a pretty big difference. And it's in the farmland. I mean, farmland is even more irreplaceable than the farms themselves, because if you still have active farmland, at least you can hopefully have farmers to farm it. But what we're finding is that we're both losing farmland and farms. And it's not just over that 55-year period. The recent history is perhaps even more disturbing. I mean, just since January of 2020, right before COVID started, we've lost 32% of our dairy farms in the state of Vermont. We went from 649, I think it was, to 439. That's in 5 years, 32%. And the percentage of organic dairy farms that we've lost during that time is even higher. I don't remember the number exactly, but we used to have, even more than 5 years ago, we had about 200 organic dairy farms. And I think now we're down to about 106. I might be a little bit off on those numbers, but it's really been a precipitous drop. And it's also in the farmland. In the last available census of farmland by the USDA, so that's a 5-year period from 2017 to 2022, we lost an additional 5% of all of our farms, and we lost 11% of our harvested cropland just in that 5-year period. So right now in the state of Vermont, about 9% of our land is harvested cropland, 9%. Farms currently own more forest than they do farmland in the state of Vermont. So, this is a big issue. And we think a lot in this state about our environment, which we should. We all care about our environment. We want to protect our environment. We want to have clean water. We want to be able to swim in the lake. We want to be able to drink. We want to enjoy the beautiful state that Vermont is. But farming is an essential, from our perspective at least, an essential part of that environment. Humans are an essential part of that environment. So if we're going to have humans are going to pollute, they're going to have an impact on their environment, but farming is a quintessential component of that. If you don't have farming, you don't have people. And so there's going to be an impact, and the question is how to balance that impact and how to make sure that we're protecting everything. We need to protect our environment. We also need to protect our farms. If we don't protect our farms, then we just displace our impact somewhere else. It's no net environmental benefit. We're going to eat regardless of whether we're eating local food or we're importing it. But what we're doing, if we don't have an environment that's allows and facilitates farming, is we're just going to export all of our impact to somebody else. And that's not fair either. We need to have an environment in the state of Vermont where we can actually embrace farming and protect it. And that's what S45 is about. And it's I believe, and it does it in a reasonable way. It is not trying to, everybody's rights need to be protected, and that includes neighbors and citizens. It's not just farmers that need protection, but the current state of the law is so unclear that it creates a legal conundrum, which no one really knows what their rights are. And that's never a good idea.
Representative Boston.
Yeah, I mean, I'm just wondering, I know we've heard testimony from lots of folks about how many farms have been lost over the years. And of course, that's something we're concerned about. I guess I'm wondering if you know, in terms of statistics, how many of the farms that have closed have been because of a nuisance loss, a lawsuit that made them unable to continue to function because of the lack of right to farm legislation? Because certainly there are all kinds of economic and other challenges without that. I mean, how many of those farms, do you have a sense? Is it like 10% of the farms that closed, it was because there was a lawsuit and they couldn't meet the guidelines or something like that?
No, that's a great question. And I don't think that's why farms primarily have gone out of business, although conflicts with towns, conflicts with neighbors, those are regular parts of farming. I think for the most part, farmers the good farmers try to be very proactive and manage those relationships. I think farmers assume some costs they don't actually legally have to assume to try to get along with their neighbors in their communities. I don't have any way of measuring that as a percentage. The reason I spotlight that sort of background is that farms are so vulnerable. Mm-hmm. And another thing we didn't talk about is the average farmer age is almost 58 now. So farms not only is the land disappearing, but the next generation is not stepping up to do it. And a lot of it is because of the cost and uncertainty. I mean, commodity prices, the highly leveraged, the cost of land, the ability to sell land for far more than you can make farming. If there's drought, flood, COVID, there's all of these factors that are constant labor, constant stressors on farms. And the concern about, from our perspective about nuisance and trespass protection is one single neighbor can easily drive a farm out of business. And if a neighbor has that just by filing suit, even if the farm hasn't done anything wrong, depending on the farm's financial capability. So that threat to farms is very real. And that doesn't mean it happens regularly, but the ability for one neighbor who doesn't like the smell of manure to drive a farm out of business it's a threat to farms. And so that's the global backdrop, and it's not, again, this, we'll talk more in detail, but this is not absolute protection in any sense. The goal of this legislation, if the farms are doing things appropriately, then they have protection. If they're not doing things appropriately, then they still will be subject to suit. And they're always subject to suit, but successful suit. So I think I did prepare a little just because this has taken a few sort of a little bit of a circuitous path, I did prepare just a handout, which is primarily just the existing statute and the version of S-45 that the Senate passed, and then also the version that Michael Grady talked to you about the other day that is what's currently in House Judiciary. So I don't know if you want to just pass those around. And then I just have a cover sheet that sort of identifies each of the ensuing statutory protections and just our quick, brief thoughts on it, just to try to help you organize at least where we are on this bill.
This entire document is on our committee page today too, if people want to look at it electronically or people watching on Zoom want to see what we're looking at. Representative Lipsky.
You know, appreciate the disturbing trends. But what's the nuanced difference in numbers of farms, if they're small side hill farms, we've lost, but we've also seen the expansion of larger farms that may lease or utilize for crop or crop production or grazing of former farms that at least retain. Is that the active maintenance of productive farmland? Is that a trend that could be good news in this declining list of statistics?
Well, that's a great question. I mean, the Agency of Agriculture.
Observation, but I don't.
No, there's,
Data.
I don't know that perfect data exists on this issue, but the Agency of Agriculture and our secretary is sort of very adamant that we support all types of farming. That includes the smallest farm and the biggest farm. We obviously want those farms to be doing everything appropriately. I think the economic reality, many small farms can't be viable. And even the small farms that are viable often have outside sources of income to help support the farm. So just the nature of economies of scale and competing against much bigger operations in different areas put a lot of pressure on farms to consolidate. I've talked to many farmers who've told me, I'd much rather be with my son or my daughter and 50 cows, but that's just not viable anymore. You have to buy a tractor, and that costs a certain amount of money, regardless if you have 50 cows. And granted, if you have 5,000 cows, you need more tractors, but just the price, the ability to competition, which is good for the consumer, but not necessarily good for the individual farmer, constantly puts pressure. And so in order to compete, I think everybody's trying to increase their production. And that's true, obviously, for dairy. And the reason dairy gets so much attention, as you all know, is it's such a big driver of farming in the state, but it applies to vegetables and fruit as well. If you have a bigger orchard and you can have your own value added production, that creates a revenue stream that's not there if you're just having a pick your own blueberries or a small pick your orchard. And this is not just farming, this is across industries. There's tremendous pressure on people to get bigger and better. I mean, when you talk about the labor costs, being able to afford things, to be able to actually competitively attract people to work at your farm, but also be able to afford the taxes, the workers' compensation. The housing that a lot of farms provide, there's just tremendous cost. And the research is that most farms lose money. And so that's a financial reality. And that's why it's so tenuous if you get an unexpected expense, or if suddenly your tariffs go up and you have to, and your cost of production goes up. Farms are vulnerable. And so I think from our perspective, at least, creating a universe where they can be viable as much as possible is critically important. And this nuisance protection is never going to address all of those issues. But farms are particularly vulnerable to wealthy neighbors. And the reason that wealth matters is it's very expensive to bring a lawsuit, and it's very expensive to bring a successful lawsuit. But if you have resources, it's not a big problem. And if you have a summer home in Vermont or a winter home in Vermont, and you come here periodically, and you're not accustomed to the farming operation that maybe you may have moved in next to, or maybe starting next to you, and you don't like it and you have resources, you can potentially drive that farm out of business. And if a farm is actively polluting that neighbor's land or is actively causing impacts to that neighbor's land that are untenable, that's a reasonable outcome. But if a farm is doing everything in accordance with all of the very stringent standards and requirements that this state has set for farms, then perhaps that's not a reasonable outcome.
Representative Nelson, you're next.
Thank you. So this bill is to protect all farms
Correct.
and change your farm use. You know, it could have been a cornfield and on great soils, and now it becomes a multi-use diversified agricultural enterprise with pigs and chickens and veggies and a farm stand. And, you know, I look at this bill protecting that person be able to grow their crops and their produce and their products and market it themselves right there on an on-farm accessory building and do what they want to do. But if I got this right, and
It's absolutely designed to protect all farms from their reasonable activities. But even more than that, I mean, and there's no statistics to back this up, but it may actually be more protective of the smaller farms that are in more congested areas than of the bigger farm that maybe has 1,000 acres and is not particularly close to others. I think it's very site specific. In other words, the closer your neighbors are to you, the greater risk that there is to you. So smaller farms often don't have the resources or to have a great deal of separation or land that maybe is fallow or forest land that may separate them from neighbors. So at least arguably, it's more protective of the smaller, or at least the more congested farms, which I think often can be and are smaller in size. But yeah, it doesn't pick and choose between large and small. What it does, and I think it'd be helpful now maybe that question is a good segue into if you just
One other question here, Representative O'Brien. Sorry.
Yes, Steve, I just wondered, in states where there are very strong right to farm laws, like I think Michael Grady mentioned Oregon, for example, are there distinctly less suits brought by neighbors against farming? I just wondered if it acts as in those states, it acts as a preventative or at least sort of de facto blocks so that it only gets the first stage before a judge or a jury throws it out and says, no, farmers have a right to farm.
I don't know of any research that's actually evaluated that question. And you'll hear from the folks who are opposed to this bill that there's no problem because there aren't many lawsuits. That's kind of been the standard pushback on this bill is like, what are you talking about? This law is fine. There aren't lawsuits. We're going to talk in a moment about why we believe the law is not fine. But there are not a lot of nuisance claims brought against farmers. I don't know of any way to determine the exact number because Superior Court decisions are only published when there's actually a decision, and they haven't been published for that long in a searchable database. So there may be a lot of suits that are filed and settled where unless you actually go to the courthouse and review every document, you're not going to know the number. I don't think there are a lot of active lawsuits, but there are a lot of conflicts. It's very common for neighbors to complain about farms, and that leads to us going out and doing inspections and doing our work. But the opponents want you to think this doesn't matter because there aren't lawsuits. The fact that there can be one and the fact that if there is one, it will follow the current structure is what I would urge you all to focus on. And so in the last 22 years, there have been 4 times where a nuisance claim against a farm has made it all the way to the Supreme Court. So it's not that it never happens. I don't know exactly how often it happens, but I do know of always a handful of circumstances where it's possible.
Do we have numbers also on farmer neighbor mediation? Because that's sort of the first step oftentimes, I understand.
Well, I mean, so that's an interesting point. And mediation is a part of S45, a required part of S45, which only means an attempt. There is no current pre-suit mediation requirement. We encourage people often to go to mediation. The United States Department of Agriculture currently offers a free mediation service. Whether or not that will continue, I don't know. But there is a free service right now that we routinely recommend that people utilize. I'm not really certain how often they do. But it is, and this is true across the board, not just if you're a farm. going to court to resolve a dispute is a loss in and of itself, which doesn't mean it's not worthy and warranted. But if you're in court, you're spending a lot of money and a lot of time. And the more complex it is, the more expensive it is. So it's always why any good lawyer will tell you, try to work it out if you can, even if it's not exactly what you want. Because even if you win at the end of the day, you're likely to be farther behind than if you can solve it quickly. So that's just good pragmatic advice across the board. But despite everyone's best efforts, that's not always possible. And so that's the backstop, is if you're not able to resolve things, you need a legal system that's effective at fairly resolving those disputes. And in our opinion, and I think if you don't mind looking at the current statutory framework, so it's right at the second page of what I handed out. Is the
Excuse me,
current law.
before we start looking at that, I've had my hand up for a little bit and I would love to, before we pivot, ask a question.
I'm sorry, Representative, I can't see your hand on the screen, so apologies.
Okay.
Go ahead.
Great, thank you. So I think I want to acknowledge that we've been hearing a lot around the closures of farms, the loss of farmland, the challenges in access to land, the barriers in fair pricing, the struggles in succession planning, the troubles that young farmers have entering into it, farmers aging out. And I think it's important to note that nothing in this bill addresses any of those outstanding issues. So the right to farm is ever so slightly misleading in that it isn't actually a holistic tackling of working to address those really persistent and nagging barriers to actually creating a more thriving agricultural economy. And so I'm curious if it's safe to say that with the trends you've recognized in consolidation and farmers needing to get big in order to compete at a commodity scale that is not reflective of an appropriate scale for our state, that this nuisance protection law is going to come into play more as farms continue to grow and is not something that is needed now, but will be as you continue to see these shifts that aren't being addressed through other measures. Thank you.
Sure. So thank you for that, Representative Supernaut. That raises a lot of important questions. I don't agree at all that this law is not needed now. I think it's been needed for a long time. It's been in place for a long time, but we'll talk in a moment about why it was changed back in 2004 and why it was changed for the wrong reasons, but reasons that were validly contemplated at that time. But all of those bigger, this is a protection that exists to protect farmers from lawsuits by their neighbors. And so given that farms are one of the few business entities that operate out of their home, at least in a way where they're using the land and actively creating, collateral impacts, noise and dust and odor potentially. I mean, there are not many business entities that work from their home and have sort of those collateral impacts. So I think farms are somewhat unique in that respect. And at their baseline, they're the ones feeding us. So the question, I think the policy question is for the legislature, how do you want to draw the line when you're determining what farms can do and what they can't do when they have impact on their neighbors? And what I'm urging this committee to consider is that the current legal framework is really poorly constructed. I'm not asking that you don't have a legal framework. Instead, I'm asking you to define that legal framework. And it's an interesting point that the common law, so nuisance and trespass claims come from the common law, England. They're old laws that have existed because of judicial opinions for centuries before there was regulation. These laws are something that's carried over. They're property claims but property owners have always had certain rights. And so those common law claims are baked into property claims. But states, governments didn't used to regulate farms and didn't used to regulate activities like they do now. So over the course of decades now, but more dramatically more recently, the state required regulation of farms has gone up and up and up and up, but the property law claims haven't been adjusted. So the whole pitch of this law is to, instead of have individual neighbors and individual courts, decide what each farm's and each neighbor's rights are, for the legislature to decide what the rights are, to apply the law so that everybody knows when they're doing things correctly and when they don't. It's kind of like if you want to cite people for speeding, but you don't have a speed limit. If you're just going to allow every neighbor on the road to determine who's going too fast, that doesn't establish a standard that's really good for anyone, because no one knows what they can do and can't do. So what we're suggesting is, since farming is so heavily regulated now, which is important to protect water quality and important for other reasons, if it's so heavily regulated, why not let those regulations establish the standard instead of leaving it up to every court's and every neighbor's subjective judgment about what's appropriate or not? I don't know if that answers your question, Representative Supernatter.
Well, not quite, but I think I would push back ever so slightly on the narrative and acknowledge that neighbors are not suing farmers. So the need for clarification actually seems to be rather null. And I think that I also want to circle back to the commentary around saying that small farms can't be viable. I think that that's a really precarious message coming out of an agency that says they support all farms. I think that I would ask our committee to think about what is the style of agriculture that we are looking to support in our state? And is it one that supports expansion at the cost of small farms while saying that they cannot be viable, and saying that nuisance protections are what is going to protect farms and keep farms farming? And I think that this is a really tricky and problematic approach to something that we know is not going to save the agricultural economy or the industry. So I appreciate your persuasive comments, but they're not addressing the heart of what we all know to be real barriers to the industry. So thank you.
No, and thank you for that. And I would, if I said that I don't think small farms can be viable, I misspoke. I was trying to explain that from our perspective and what I've read and heard and talked to about people, it's challenging for small farms to be viable. We absolutely want them to be and encourage them to be and are thrilled when they are. But there are certain economic pressures that, as I understand it, make it more difficult for small farms. But to your point, there's a duck farmer in Essex who's got a half an acre plot of land, who's trying to farm in their neighborhood, and they're in front of the Supreme Court right now because their neighbor objects to the operation. There's a farm that's down on the Lake Champlain in Panton that was sued because of both alleged water pollution and also because of the smell of manure. And the smell of manure is a pretty dangerous thing to allow a suit for. This plaintiff, who has a summer home on the lake, prevailed in that lawsuit, and the court said to the farm, "You've got to stop your manure from smelling." Now that is a pretty difficult standard, and what really is kind of, I guess, troubling to us is that the state of Vermont has instituted a series of requirements that farms have to follow with their manure management to protect water quality. These are important standards, but most farms have to have 6 months of storage of their manure, which is incredibly expensive. They used to be able to spread it all year round whenever they want. That's not good for water quality. They can no longer do that, but that means that there's an incredible infrastructure cost for them, where they have to be able to have storage enough to store both their manure and their water for 6 months of the year, and they can only spread it when the conditions are favorable for them to do that. Well, the neighbor complained that certain times the smell was really pungent and she couldn't enjoy her front yard. That's a reasonable concern for a plaintiff to not like it. But the question is, what does the state permit? And if a farm is properly storing its manure and it's properly spreading its manure and it's properly complying with a lengthy litany of requirements that it has to store its manure, do we want to allow courts to enjoin farms from having smelly manure? That's a policy question. From the agency's perspective, if a farm is managing their manure appropriately, they should not be subject to a lawsuit, a successful lawsuit from a neighbor because they don't like the smell. If farms are not honoring the setbacks for the manure, they're not managing it appropriately, they're dumping it in the river, they're dumping it on their neighbor's land, all of those things are already precluded and not allowed. So whether the law changes as proposed or not, a neighbor would continue to have an actionable claim based on those grounds. But the idea that you can tell a farm not to have smelly manure is one that we don't know how to recommend to solve. Even if you were to cover the manure pit, there's serious questions about managing the methane that would accumulate. And I'm no expert on this, but it's not like there's even an answer, even if you had the resources to make your manure not smell. So these are pretty important issues. And I think they apply to the small duck farmer. They apply to, and the bigger farms too. And it's not, no one at the Agency of Agriculture or the Senate, which, so overwhelmingly supported this bill, is suggesting that farms not be accountable. Their request is that you make farms accountable to a reasonable standard they could adhere to, rather than allowing subjective assessments by individual courts and individual neighbors.
Right, and thank you so much for that. And this will be my final point. And I just would like to remind the committee that not a single farm in the state of Vermont has ever been shut down because somebody didn't like the smell. So just remember contextually what this bill means.
So I saw Representative Burt had a hand up, and then I'm going to ask that we do let Steve continue with his testimony. Go ahead, Representative Burt.
I was just gonna, this bill would also, just for clarification for my sake, if you have like a small CBD hemp farm, right, which driving by some, I'm surprised by the smell coming from the fields during a certain time of the year. Would this protect farms like that as well from nuisance claims?
Hemp is agriculture, so hemp production would be, again, if they're following all the requirements that apply. And there's a pretty loose additional standard there that we'll talk about in a minute. Cannabis is governed by the Cannabis Control Board, and some of farming's protections were extended to cannabis about 3 years ago. I don't remember if right to farm nuisance protection was one of those or not. It's easy to find out, but hemp is an agricultural practice. There are not, I don't believe, very many folks in Vermont who are currently only growing hemp.
And I just feel like when you feel like you have, we've definitely dealt with stressors over the years on our farm of cows getting out and getting into somebody's garden, and that's just an example, of ways in which you can disgruntle neighbors. And I think I see the value of having, feeling like you got something in statute that's protecting you a little bit more, no matter what size farm you are. So I feel like I'm glad to see the language that's in here personally.
Well, should I continue? So thank you for that. I think from my perspective, the legal perspective, the best reason to understand why the current law is not workable is to look at it. And so if you look at it's pretty pithy section of law, and everything Representative Supernaut said is correct about the right to farm not being this encompassing right to farm. It's a civil defense. It's a protection to nuisance claims and potentially protection claims. It's limited in scope. It does not resolve all those bigger questions. It does, however, provide an important protection to farmers whose neighbors don't like their activities. And so if you look at the legislative findings in the purpose section in 5751 and 5752, those are great. The findings and purpose talk about all those things I mentioned briefly in the beginning. It's saying the state of Vermont values farming, which kind of obviously, right? But sometimes we forget a little bit about what that entails. The problematic part is the actionable part of the statute, which is 5753. So that's the second page. Normally, I assume everyone knows this, but normally when someone files a lawsuit, they have to prove their claim. In other words, in our system of justice, the burden is on a plaintiff to prove that they've been wronged by a defendant. And so when they bring a claim, that's what they have to prove, which is very important in litigation because then the defendant is allowed to respond to what the plaintiff is alleging instead of just broadly trying to prove that their own innocence. So as an example, if you were going to prove that someone assaulted you and hit you, the plaintiff has to say when that happened, what they did, and what the damage is. And then a defendant is able to is able to create their defense based on the allegations. This protection is backwards. This protection that exists today creates a burden on the farmer to prove their innocence. And that's not how our jurisprudence works. It might be worthwhile quickly saying why. The reason it's as it is now, and I've learned this mostly from Mr. O'Grady, is that our nuisance protection is pretty similar to Iowa's nuisance protection. And back in 1998, the Iowa Supreme Court issued a decision that found their nuisance protection to constitute a constitutional taking. And what that means is in our system, the government can't take someone's land without compensating them for it. Makes perfect sense, right? If the Iowa Supreme Court found that the setup of their statute constituted a taking. And so that led to, as I understand it, the legislature in 2004, when it last looked really substantively at this language, of creating this back and forth test, which is why the law is, in my opinion, so flawed now. It makes perfect sense why we got where we did. But the Iowa Supreme Court, when they issued that decision in 1998, has since not entirely abolished, but almost entirely abolished that decision that they had in 1998. And every other court that I can find in the United States, and any of the United States, has completely rejected the opinion that a nuisance protection can be a taking. So in other words, back in 1998, one state Supreme Court found that this nuisance protection could create a taking. Every other court in the US that I've been able to find, and I think everyone else that's testified on this issue has been able to find, has totally rejected that theory. So the reason the statutory framework puts the burden on the farmer to start is because of a Supreme Court decision in Iowa that's since been repudiated. So it's time to clean it up. There's no reason to have this kind of standard that stems from bad precedent a long time ago. But it's not only that the burden is on the farmer, which is not how our system typically works, it's that the burden isn't even clear what you have to do. And if you look at each one of these A, B, and C, and D, there's 4 different subsections, but there's a lot more than 4 potential issues. I mean, a farmer right now has to prove they're in conformity with federal, state, and local laws and regulations, including the RAPs, required agricultural practices. That's fine if you're looking at one date and time and saying, did you do something appropriately on this one day? But that's not what the law says. I mean, this is so broad and ambiguous that it's not clear what a farmer would have to do. As an example, if a farm had a wetlands violation, does that mean that they can't get nuisance protection for their smell? Even though they're completely unrelated, there's no connection at all. But this says a farm has to prove they're following every law. Does that mean if their truck is not properly registered, that they can't have nuisance protection for noise? It's this broad encompassing scope that's not related to the harm that's alleged. So that in and of itself just means that a farm has to potentially prove all kinds of issues that are completely irrelevant. And more troubling, it's just not clear. You never want a law that people don't know what it means. And I will tell you, the first time I ever read this statute, I got through the first 2 sections and I said, this is great. Vermont cares about farms. And then I got to this section and I said, and I've done a lot of litigation in my career. And I looked at this and thought, no one has any idea what to do with this. This doesn't make sense. And the problem with not making sense is it means it creates arguments for the parties. And whenever the parties are arguing about issues, which they always do in litigation, but if they're arguing about disputed facts, that means the court can't decide it without a trial. So if you file a frivolous lawsuit and you don't have any facts to sustain your claim, then the court can get rid of that claim fairly quickly. If there's disputed issues of material fact, it has to go to trial because the trial court can't decide those factual issues. So even if 50 people say, I saw him do it, and the one person says, I didn't do it, that's a disputed issue of material fact that a court can't decide unless the court is presiding in the trial. So either the judge has to decide it in trial or a jury has to decide it. Why that's problematic is that extends the period of litigation. So now instead of talking about 6 to 12 months of litigation, maybe if you don't have many facts and you can file your motion showing that there aren't any facts, you're talking about maybe 3 years of litigation. And why that matters is that attorneys are expensive and experts are expensive. And you could try to defend this claim on your own, but good luck. I mean, if you're going against a lawyer and a plaintiff with money and you're a farmer in court trying to defend yourself, you're going to lose more than likely. So if you hire an attorney to defend you, I don't know the exact rates in Vermont, but it's probably $250 to $300 an hour at least to hire an attorney. For 40 hours of attorney time, that's $10,000 to $12,000 just for 1 week, one week of time. So if you're in litigation that goes to trial and you're spending a few years on all of the discovery, which means all the paperwork, all the depositions, all of that work, you're talking more than tens, at least hundreds of thousands of dollars to defend yourself, even if you didn't do anything wrong. So litigation is an important recourse for all people, but the clearer that you can make the law and the better that you can make the standards, the more power you give to courts for the parties to know what their actual rights are and for courts to be able to decide a case expeditiously. So, and so the second factor is a farmer has to prove that everything they're doing is not only in conformity with every law, but also with good agricultural practices. That again is an amorphous standard, and you're probably going to need an expert to testify about what a good agricultural practice is. So again, if you get one expert saying one thing and another expert saying the other, that's a disputed material fact. So it's not, and the next thing a farmer has to do, and this is very ambiguous, is they have to prove they were there before surrounding non-agricultural activities. Well, what does that mean? Is that your immediate neighbor? Is that people two miles downstream from you? Is that people 5 miles away who might smell your manure? Or if you have a field that's, I mean, it's just, not only do you have to show you're there first, but it doesn't even define the scope. I've seen some other states use something like a half-mile distance or use other barometers, but this is who was there first. I mean, you might have to look through decades of land records to figure out who was there first. And since development has been encroaching on farmland throughout our history, you're probably not going to be able to prove you were there first, not vis-a-vis everyone. So the point is, this is a really ambiguous standard, but it's also not a usable standard, especially when you look at the purpose, which is Vermont wants to protect farming. So the reason this is in there is it comes from an old standard it's called coming to the nuisance. In common law, people were protected from people who are quote unquote coming to the nuisance. So if you were a neighbor moving in to an existing nuisance, then you were not allowed to complain about that nuisance. And, that's an understandable standard in the common law when there are no requirements about how farms have to function. But our position is that now when we have, more people, we're going to continue to have more people, and we're trying to protect farmers on less and less farmland. It probably makes more sense to have a better standard than who was there first. And the standard is, are you doing it right? So that's kind of the pitch on that particular front. And then this last one is the worst one, actually, because it says a farm has to prove that it has not significantly changed since the commencement of the prior surrounding non-agricultural activity. So if you look in the purpose section of the statute, it says that farms need to adapt and change and grow and diversify. I'm not sure if it uses the word diversify, but it makes it very clear that farms have to change. And that's true throughout our history, whether you talk about going from sheep farming to dairy farming, to diversifying, to value added, to expanding to produce and vegetables like wheat, and to honey, and to maple. Farms need to adapt and change and survive in order to be viable. That's our farmers' greatest strength. The reason that we still have farmers in Vermont is because they've shown an ability to do that. And what this law says is if you significantly change, you don't have any protection. That's horrible. I mean, the Agency of Agriculture, in this legislature have been encouraging farms to adapt and change for a long time. And in this law, we say if you change, excuse me, if you significantly change, you don't have the protection anymore. I mean, that's counterintuitive and problematic. So, I mean, that's to me is by far the worst of these standards. It's again vague. What's it mean, significant change? Does that mean going from alfalfa to corn? What is that change? If you go from corn to blueberries, is that a significant change? If you use conservation tactics, or like really smart in conservation techniques like injection, is that a significant change where you lose the protection? So that all of these reasons, I mean, first of all, the farmer has to prove all these things, but they also sort of defeat the purpose of having the protection in the first place.
Yeah, for instance, we went from being farm based on dairy and we converted quite a bit of our acreage to apples, and part of with growing apples, I see the folks here, be advocates in here just a minute ago, but ideally you want to spray it like 3-4 in the morning. You're gonna put on sprays in order, so the least amount of insect activity taking place while you're doing it. But I have neighbors, and one of my neighbors, which they're, I was shining the headlights in my tractor right into their windows. Is that part of what this is talking about?
Yes. Yes. I mean, if you're doing, so the list of agricultural activities is in the definition section. It's also in Title 10, the farming definition. It's also in agricultural activities. So yes, if you are making noise, if you are doing things that are allowed, you can't be driving across their property, shining the lights into their house. But if you were on your farm spraying at the time that actually protects pollinators, and you're doing it in conformance with the pesticide rules, then yes, this is the kind of thing that should be protected. Now, I assume you probably love to talk to your neighbor and ask them to put down a shade and, explain what's happening. And ideally that's a problem.
Maybe try to plant some sort of, shrub or something on the edge of their, on your property, but on the edge of theirs to block it. But, obviously you want to have those conversations and mediate those things outside of going to, to lawyers. But, I think it's a good thing, because you could have a neighbor that just will not, have it. Like you're supposed to be dairy farming, and if you switch to apple, it's your fault. There's nothing you can do to get out of, a lawsuit basically. So I think this is much needed for, in my opinion, a whole host of possibilities on farms myself.
Well, and maybe even a more likely result is you start making cider, and that operation makes some noise, and maybe you're operating in off hours and there's some noise there. The question is, if you're doing things appropriately, are you protected? And even though you want to have those conversations, maybe you adjust your hours because of the neighbor, maybe you do all kinds of things. If you don't have that legal certainty, then you're really kind of you're in a vacuum. And that's a law. People should be able to read a law and know what they can and can't do. And so that's the whole point of legal requirements, is making risk assessments. Nobody should want to be involved in litigation, but if you're going to be in litigation, you at least want to know what your odds are as best as possible. But currently, according to this law, if you went from a dairy to an apple orchard, you don't have any protection. And that doesn't make any sense. So, that's one of the fundamental reasons that this law needs to be changed. So I was going to go on to the version that the Senate passed, if.
Representative Bosland.
Yeah, I mean, I just hearing some of these specifics are useful for me in terms of thinking about the various scenarios, and like the situation that Greg just mentioned, like if I mean, no offense, but if I moved in next to Greg and he has a dairy farm and I'm like, oh, okay, there's cows, there, smell of manure, whatever, like you kind of know what to expect. And if it entirely changes to an apple orchard and suddenly there's a heavy use of pesticides, and that's a different kind of exposure for me and my grandkids and my pregnant daughter who's visiting or something like that. And so to me, it doesn't feel unreasonable to have some kind of look back at if the rules change and he's growing something different and there's a different kind of risk for the neighbors. To me, maybe that does feel different.
Understandable, and there's a couple of things I would say about that. One is that the pesticides rules require you to keep pesticides on your own property. So that's, that's part of it. If you're not doing that, then you're not following the rules and you are potentially susceptible to suit. The other thing is that's the coming to nuisance kind of standard defense. Some states have adopted something they call a statute of repose, which gives a year for a change of activity. So that if no suit is brought during that year period, it's not just a statute of limitations, it's a statute of repose, which means you just can't even bring a suit. Statute of limitations, you could challenge whether or not the limitations apply when you discovered it. There's a bunch of sort of caveats. So some states have done that. That's something reasonable for you all to consider. I guess on that point, I would say that in part because there aren't a lot of lawsuits and because farmers, we think, are pretty responsive to their neighbors' concerns, that maybe that's not something that's required. But also keep in mind, first of all, this doesn't stop anyone from filing a suit, what's proposed. But also, if a farmer's not following the laws that you all require them to, then the suit's viable. So, there are, and that's what I often say is if you think if the regulations on farms aren't adequate, then I would suggest then the regulations should be addressed rather than leaving it up to an ad hoc neighbor by neighbor approach of what's permissible or not permissible. Because that's bad I think for both neighbors to know what their rights are and also the farmers to know what they can do and can't do. That sort of uncertainty, like maybe you don't switch to a certain activity if you know that it's not allowed. But if it's within the rubric of allowable at farm activities, then ideally, it's something that's worth protecting. But people absolutely wonder about that. What if you change? And, if you change from certain activities have more potential impacts than others, for sure.
All right, should we go on to, I think you were maybe going to have us look at the Senate changes.
So what the Senate did. Yep. So if you go to S45, it's attachment B in the little handout that I gave. But I think I'm not going to go through it all unless you want me to, but I'd rather sort of talk about the bigger pictures unless you have a bigger picture, unless you have questions. But the key to what the Senate did, if you go to page 3 of 6, the top line, is they defined what generally accepted agricultural practices are. So instead of using the standard where the farmer has to prove what they did, the Senate said, this is what farms have to do. And the first line, so it's the requirements of 6 VSA chapter 215. So that's the water quality chapter where we regulate farm water quality. And that includes things like the LFO permit, the MFO permit, and the required agricultural practices. So what the Senate did was say, farms, you already know this, you have to follow these laws or you're susceptible to the Agency of Agriculture bringing an enforcement action. But they're also saying, farms, you have to do this or you're susceptible to a neighbor suing you in nuisance because you didn't follow these laws. It's top of page 3. That's yeah. The next thing the Senate said was you also have to meet the requirements of the control for pesticides, the Agency of Agriculture's rules for the control of pesticides. So again, if you're using pesticides, you have to use them appropriately, which is according to the label and also with our requirements. So again, it's saying farms, you don't have carte blanche to bother your neighbors. You got to follow the laws, and these are what the laws are. And then the third category is the sort of catch-all that unfortunately kind of undoes the clarity of what the first two do. And it goes back to a more ambiguous standard, which is farms also have to follow proper and accepted customs and standards followed by similar operators of agricultural activities in the state. This, do you want?
Let's let you finish it.
Okay. So this kind of undoes some of the clarity for the water quality and pesticide requirements, but we accept it as a reasonable balance of those interests because the water quality regulations and the pesticide regulations don't regulate everything. And so because they don't regulate everything, they're not necessarily dictating appropriate conduct on everything. So this kind of catch-all provision means that if a farm is doing something that is not regulated by those other provisions, then it still has to be appropriate in accordance with accepted customs and standards. And that's a standard a lot of states use. It's not so different from the current good agricultural practices that's in statute. And it could require an expert. So that's an issue. You might need an expert, and there might be the battle of the expert. But the key difference, that we'll talk about in a minute, is the burden is on the plaintiff to prove the violation rather than on the farm to prove they're doing everything right. So, yeah.
So if I understand correctly, C is intended to cover those areas that might not be covered by A and B, essentially. It may introduce some ambiguity, however, that we might want to be thinking about. Is it necessary to have C?
I don't think it's legally necessary to have it. I think, we recognize it as no one's trying to take away neighbors' right to use their property, to use and enjoy their property, or to keep people off their property when they're not supposed to. So it is a balance. This one does create some ambiguity, and it does create potentially some of those factual questions. But with the plaintiff bearing the burden of having to show the farm's doing something wrong, I think that's an important change, because if the plaintiff has to show the farm is not following accepted custom and standards because they're doing A, B, and C, and they've got an expert to do that, then the farm can respond to that and can respond appropriately to that. If the plaintiff is just saying they're not following accepted customs and standards and practices with no facts, no evidence, then that claim is going to be thrown out. And so that's, in part why the balance, I think, is at least tenable, but no, it doesn't have to be there.
Representative Nelson.
Yeah, thank you, Chairman. Counselor, C says that I can till my fields and plant corn, or I can grow a perennial crop on my fields, or I can no-till my fields, all acceptable agricultural practices. That's what C says. Another way to look at it is if a stream is artificial lure only, acceptable would be to fly fish or to throw lures. Required is that I use lures and not bait. So, the required practices are I have my permit and my nutrient management plan all drawn out, and I follow it according to the laws of the state and the required practices. But acceptable is I have different modes of application that I can use that are legal. Required is I stay so many feet away from a ditch or a stream. But acceptable is I can hay it or leave it as a buffer.
There's certainly room in C to accommodate all of those practices that are conducted in accordance with.
That's what C says. Yes.
Right. And keep in mind that what's protected in subsection 2 is generally accepted practices, and then they're defined by all of these things. So if a farm is meeting A, B, and C, or even just A and B, but C doesn't apply, then you enjoy the protection. And the flip side of that is that it's the plaintiff. So if you go to the next page, to page 4, the language that is not stricken says no agricultural activity shall be or become a nuisance or trespass when the activity is conducted in accordance with generally accepted agricultural practices. So those generally accepted practices are all of A, B, and C that we just talked about. So if you are following those requirements, it's not a nuisance. And in the Senate's version, or a trespass. Yeah, I know.
Representative Burt, and then I've got my eye on the clock, and I want to be sure that we have you until 3, Steve, and if we run a little long and you're able to stay, that's fine with me, but
I'll stay or come back or whatever works.
Right.
Sorry, just a quick question. So, like in the case I gave about shining headlights, like, or if you're a sugar maker and you gotta gather your tank in the middle of the night and your lights for your truck go into your neighbor's window.
I don't know.
I would rather that guests didn't speak to the witnesses.
It's on.
You-
Sorry, thanks.
Um,
Sorry, Representative.
No problem. That's an activity that's not regulated by the state, right? What time you would gather your sap at, and things related to headlights shining in people's windows. That's also probably what that section C is for, I guess. Is that correct?
Yeah, it's a little confusing, but there's a list of activities that are part of farming, and that's what this committee worked a lot on 3 years ago. And those are not all in this statute. Part of them are in chapter 215. There are agricultural activities and there's farming. So what you talk about, spraying your crops, that's an agricultural activity that's protected. The term generally accepted agricultural practices is a term of legal art in this bill because it's saying if you're meeting those standards, then you are protected. So driving your tractor on your field is absolutely a farming practice. If it's generally accepted, if you're meeting the requirements that are specified and also in standard with, common standards and purpose. So it's kind of a two-part thing. First, what are you doing? What's your activity? If it fits within that very broad rubric now, because this committee made it so 3 years ago, then as long as you're not violating a law, then you're covered and you're doing it. If you were blaring your music as loud as it could possibly go at 3 a.m. on your tractor, that's probably not a common standard of practice that you need to do for farming. So I think that would be a viable claim that wouldn't fit within generally accepted practices, but spraying your crops at night so that you don't kill pollinators, that's going to fit within the standard.
Representative Boston.
Yeah, so I have a question at the top of page 4, where it says no agricultural activity shall become a nuisance or trespass when the activity is conducted in accordance with generally accepted practices. So I'm just thinking about a scenario where, let's say that an animal is on the property and it's causing damage to the crop. The farmer has a right to kill it. So like a bear comes and he's eating all the apples in the apple tree, the farmer has a right to kill it. So in terms of the become a nuisance or trespass, if the bear that has destroyed a bunch of trees eating apples is being pursued by the farmer, he can then go onto my property next door and kill it? Like, what does that mean when it says you can't do trespass? If it's generally accepted to kill the bear that's eating your apples, say, how does that apply or not apply?
That's a great question. And that's a key, not specifically that example, but the issue of trespass is a key issue that the House Judiciary has been grappling with.
It's like a cow wandering onto my property feels really different than a farmer with a gun trying to shoot something when it gets to my property.
You can't, if I want to kill a bear destroying my cornfield,
Yeah.
I have to shoot it on my property. You have to get a permit from Fish and Wildlife and you have to take it on your property. I cannot come, when I get to the edge of the property line between you and I.
So that wouldn't count, that where it says it's not trespass. It might be if you walked on my property, but not if you're going to shoot the bear.
Even if I walk on your property
Yeah.
with a weapon and you don't want me on your property with a weapon, then I am trespass. Absolutely. You have protection for your property.
So what does it mean when it says there's no trespass?
So maybe we can let Steve answer that, but I think that broadly speaking, in this context anyway, we shouldn't think of trespass as walking onto somebody's land.
Yeah.
It has more to do with sending water onto someone's land or sending a smell onto someone.
Okay.
Yeah, but
Okay.
if you want to,
No, I think that's right, Mr. Chair. But it's not, arguably, it's not crystal clear how it's defined right now, but there are two different things. There's civil trespass, which this is about a neighbor's ability to maintain the exclusive use of their own property. That's trespass, civil trespass. There's also criminal trespass. And people can't, if you tell people they can't go on your land and they do, that's criminal. And this wouldn't even think about dealing with that issue. But I think a key issue for this committee probably to weigh in on is if you're going to have, because the House Judiciary is grappling with whether they want trespass or not, and if so, how, I think is what type of trespass do you want to protect against? when trespass was included in S45, I don't remember a lot of discussion about the scope of that trespass. In my personal opinion and my sort of assessment of it, it's always been about farms' ability to farm their own land. And when they're doing that, some of what they do can cause a neighbor to bring a trespass claim. It's extremely, and for the things like we're talking about, it could be dust, could be pesticides, it could be odor, it could be water. Like all of the things that a farm does on their land can arguably waft over to a neighbor's land and can both interfere with their use of enjoyment of the land and also arguably with trespass. And when you look at cases that are brought around the country, and there are a lot of cases brought around the country in a lot of states, they almost always bring both claims when they bring them because they're not the same claim, but there's a lot of overlay. You can claim that if pesticides come onto my land, that's both a trespass and also a nuisance. The Vermont Supreme Court looked at that issue once and did not find that it was a trespass, but it didn't rule it out. So in the state of Vermont, that specific issue has not been ruled about, but we have certainly never envisioned that a farmer could take their tractor and go plow someone else's land and plant a crop there and harvest it, and that wouldn't be a trespass. But we do want to protect the farmer's responsible farming, whether that be in a nuisance claim or a trespass claim. So that's why, we're not opposed to reasonably defining what trespass means, but we do think that if you leave trespass out, you're just going to encourage plaintiffs to rephrase their claim. And if they're just rephrasing it and they're then able to litigate based on it, that's not sort of providing the same kind of protection that we're hoping that farmers can have. But that's a good point. I mean, and that certainly can be defined. And that's one thing, another issue is whether or not if you include trespass protection, whether that in and of itself constitutes a constitutional taking. Obviously, the legislature can never, override the Constitution. So you can't, if you do pass a law that conflicts with the Constitution and the court reviews it, the Constitution wins. None of us want that. I think it's very unlikely that a right to farm claim would result in a constitutional taking, but there's an easy way to get around that. It's just to say you protect against trespass unless it would constitute a constitutional taking. So even if you're worried about that framework, which is a reasonable thing to think about, that's why the statute is as it is now, because in 1998, Iowa, in a nuisance action claim, that the Iowa Supreme Court decided it was a taking. That's all been repudiated, but this is for trespass, and it is a little different. If you allowed a farmer to take over their neighbor's property, that would be a trespass, and nobody's saying that we should do that. But protecting the farmer from the responsible use of their own land is something that we would certainly encourage you to adopt. So,
Yeah, turning it around, I just wondered if certain right to farm laws protect farmers when they're farming, almost the opposite, because something the neighbor's doing is making it hard for them to farm. For example, say I'm a beekeeper next to a golf course at Spring, neonicks, or there's a shooting range next to my goat dairy and it's stressing out the goats. So they don't, is that just a neighbor versus neighbor thing? Or are there sort of reverse claims where a farmer's saying, I'm doing generally accepted farm management practices, but my neighbor is essentially making it hard for me to farm?
So yes and no. It's not related to generally accepted ag practices, but any property owner can bring a claim saying that someone else is either creating a nuisance by interfering with their use and enjoyment of their property or by trespassing on their property. So that's just a property claim that any property owner can bring. So it doesn't only apply to farming. It's just that this protection is designed for farming. And in part, I think those reasons we talked about earlier, which is farmers are sort of unique in that they have these activities at their home, which does create, some collateral effects. And also there's a real desire to, or at least has traditionally been a real desire to protect farming so that to ensure that we can grow our foods.
nothing special for farmers in the reverse direction. It's just
No.
versus neighbor kind of.
Not that I'm aware of. I mean, there are some, I don't know how many states, but I've seen at least some that do actually allow attorney's fees for a defendant farmer. If they're sued and they prevail, they can get their attorney's fees, which is a huge benefit and a huge deterrent. Like if you're going to bring a lawsuit and you realize that if you lose, you might be paying the other side's attorney's fees. That's a big deal. And in this country, usually it's only the plaintiff that can recover attorney's fees. There are some cases where a defendant can, but there are some states who've done that. In fact, I think in a bill proposed in this legislature about 3 or 4 years ago, attorney's fees for the farmer was part of that. And that's a huge protection because if you're responsible, if money is a concern to you as a plaintiff, you're only going to bring that claim unless you're reasonably certain that you can prevail, or you're going to be spending potentially hundreds of thousands of dollars paying for the farmer's attorney.
There's also something in law, just because I know in Governor's Select Board, a different case, but that there sometimes damages almost, or counter charges almost, damages can be brought against, say, just constant nuisance suits against something, say the neighbor lost the first one, but was just essentially wanted to harass a farmer.
So there's things in common law like malicious prosecution, defamation, libel. There are things that if you believe you're being unfairly targeted, you can bring a claim. It's not easy to prove. And again, it takes resources, but there are some sort of protections, and that would be more likely to be a cross claim instead of an independent suit.
And nothing special to farmers.
Not that I'm aware of. No, I'm not aware that that farmers have any like special plaintiff protection. And this is it's a defense, right? It's like if you're going to, and the question is who can do what and what standards apply. So, we move forward. And if you're tired of me, let me know and we can resume too, because I know I can be a bit much.
I think we at the very least should let you finish up walking through the S-45 as passed by the Senate changes that you were highlighting.
Okay.
Yeah.
Great. So the next section, 57, 54, it's really just setting the tone of the legislation. It's saying that to the courts, we're serious about this protection and we want you to liberally construe it in favor of farmers, which is important because when courts are trying to figure out how to review the laws, this tells them that the legislature wants you to look at it favorably to farms, as favorably as possible. And then it also, on the next page, it allows for the changes that we talked about for farms to change and adapt without being susceptible to a new nuisance or trespass claim. And that's, goes back to what we were talking about in terms of the importance of farms being able to adapt. We encourage them to, they need to out of necessity. We don't want to penalize them for doing that as long as they're doing it appropriately. So the next section, 57, 55, is just a required mediation, which, we're very supportive of this. It doesn't mean anything if the parties don't want it to. And what that means is you can never force anyone to resolve a conflict amicably. You can only ask that they try. We think this is important because if you're only ever communicating through social media and the internet and you never actually talk to anyone or talk to your neighbors, kind of hard to resolve a dispute. So a lot of times if you can get people to actually talk and compromise, that can help resolve things. And a lot of times a mediator who's skilled can really facilitate that. So all this does, and you should know if a lawsuit's filed, courts already require mediation, but that might be 6, 9, 12, 15 months in at least before you have that mediation. Usually there's discovery before mediation. So this is just saying, before you bring a suit against a farmer, you've got to try to talk to them. If the farmer refuses, then the person can just go to court. But if they talk and they can't agree, then they can go to court. So we think it's a very reasonable approach to try to get an efficient solution, but it doesn't hamper anyone's rights if, it doesn't require a neighbor or a farmer to do anything. And I think that's really it.
You had highlighted, you had listed silent on public nuisance as a
Oh, yes, thank you.
Yeah.
So in the current law, there's an explicit exempt, so private nuisance is as a property owner who owns land and they're bringing a claim. There's also a public nuisance, which means it has a broader impact in towns, state entities, government entities can enforce for a public nuisance. So if you were, poisoning a town's well, that could be a lot of things, but it might also include a public nuisance, not a private nuisance. So in the existing law, the protection is very clearly only for private nuisances by a private landowner, and it exempts public nuisances. S45 as passed by the Senate strikes out the public nuisance language and it just doesn't say anything about public nuisance. In my opinion, that means a public nuisance is still a public nuisance and a town or a government entity could bring it. But you could be more express about that if you wanted to be. It's just, they don't mention it at all. And the reason that matters is the House Judiciary has done something a little bit different with that language. So just kind of trying to evaluate where you want to come in. The protection is designed, in my opinion, to be for private nuisances, not for public nuisances that might have a much bigger impact.
A public nuisance could be you're working a field and you're in and out of it all day long and you're dragging mud into the road. Public nuisance.
I would hope not, but potentially. I mean, I'd hope that wouldn't rise to the level of a public nuisance claim, but I think it's meant to be bigger than that, with more health and safety and welfare. Like if you had an airplane that was spraying your fields and you went over the town and, and dropped all your pesticides on the town.
Well, that's against the REPs.
Correct. But the question is who can bring a suit? And so in that case, if you spread all over a town, an individual neighbor could bring a suit. But I think as a public nuisance, the town, the municipality could also take action to ensure that didn't happen again. So it's really about who has the claim. It's whether the public has the claim or the individual landowner has the claim, I think.
So, Representative Boston?
No, I was just looking. Yeah.
Okay. So, Steve, I know that you have also provided in attachment C, which is like halfway through this document, more language, but would you like to have us invite you back perhaps tomorrow afternoon? I don't know, you'll have to work out the timing, but maybe since we're running a little bit long and committee could probably use a short pause, and I don't want to keep the next witnesses waiting too much longer either. Why don't we plan to do that?
That'd be great. And
I'll just call to everyone's attention that it's halfway through the document that Steve handed out. There's attachment C, which goes through some of the highlights of the House Judiciary changes, as well as it looks like the agency's position, and then the draft of the S45 that Judiciary has been working with. So we can all look at that on our own time, and then we'll have you back in tomorrow.
thank you so much. And sorry to take so much time, but I really appreciate the discussion.
Guys at all. We appreciate your time and answering questions.
Well, thank you. Thanks.
All right, why don't we take a quick, let's be back.